Okay. Mr. Reagan, place your appearance on the record, please.
Judge, good morning. May it please this honorable court, Philip Reagan, P57156, on behalf of Mr. Lawrence Deontay Gilchrist, judge, who is appearing from the Wayne County Jail this morning.
Argument.
Judge, my client, Your Honor, is 30 years of age, born and raised in the city. I actually know his parents. One of his parents, Judge, is an officer that raised him, comes from a very good family. Judge, he's working every day. I understand, and we look at this because of the age of the complaining witness and say this is a egregious situation. Now, understanding that everything that you read in the right is not my understanding as it exactly happened. When people come up and approach you, they grab you, they startle you, you don't know what's going on. Sometimes things happen. My client, I don't believe it's a threat. I think that once this case goes through the process, it'll play out in court. We are not here to try the case. We're not here to determine guilt or innocence. We're here to determine whether or not he is a flight risk, which I don't believe he's not. Has parents that he lives with, as father is a police officer who has raised him, not in this manner, not thing of this nature from him. He's going to come to court. Now, he's not going to have any contact with the complainant. He won't do that because he doesn't know the complaint. This case needs to go through the process. I understand what the write-up said. The write-up is a hearsay document. It's a write-up. It's the people's version of what happened. That's their version. We're going to have a different version. Once the case is tried, it'll all come out, Judge. But right now, I think the court can do a less intrusive measure than incarcerating Mr. Gilchrist. Even if the court wanted to put monitorization and house arrest, that's fine. But I just don't think he needs to necessarily just sit in jail. It's a GBH aggravated assault case. I do understand it's serious, and I'm not trying to say it's not. I just think that the court could use a less intrusive measure. Reading the write-up, he's not guilty right now, Judge. And I think we all sometimes want to presume based on the write-up that, this actually happened the way it did, when it did. So I'd ask the court to take that in consideration at this level, at the bond level, not at trial, Judge. So I'm asking the court for a personal bond and whatever conditions the court wishes to impose.
Madam Prosecutor.
As the court knows, not only is this a matter for the decision to be on a flight risk, but it's also an issue of public safety. Under MCR 6.106, pretrial release can be denied for a violent felony. Here we have an unprovoked felony. The victim is over 80 years old, and the suspect informs the police at the scene, "I knocked his ass out," end quote. This incident took place at 10:15 in the morning. Under Section D, the pretrial release may be considered for the mental condition of the suspect. Here, the suspect has had an involuntary mental hospitalization as recent as October of 2020. In this case, again, it's an unprovoked attack on a stranger from another country visiting the city. And again, excuse my boldness, but he simply cold-cocked the victim. As to the possibility of a conviction, counsel has stated that things are not as they seem in the report, but the police officers obtained video of the interior of the CompuWare building lobby where this occurred, as well as the surrounding exterior areas. Here, it's clear that there are no prior interventions between the suspect and the victim. Furthermore, the incident is captured in its entirety on the video, where the suspect walks up to the victim, standing so close to the victim, and then without provocation, violently hits the victim. As such, the probability of conviction and sentencing is strong, given the entire incident does take place on video, as well as before the incident. While the individual, as counsel states, resides in the community, he is a danger to the public. His behavior is unpredictable and violent, and to be direct, he is a loose cannon and is a danger to our community, the victim, and the citizens of Wayne County. At this time, the condition of the victim is critical, and obviously the people have concerns based on the gravity of the injuries. As such, the people request the court maintain a high cash bond to ensure the victim's safety and the safety of the community.
Judge, and I do have respect for counsel. I disagree with the interpretation of the statute for this particular GBH crime, Judge, in terms of denying bond. I will say, Judge, when it comes to video, and what video is, I haven't seen a video, and I do understand how video gets misinterpreted just because in the report they say they have video. A lot of times, video isn't seen, and I'm not saying that Sister APA hasn't seen the video. I know I haven't seen the video, but I know when officers say they have a video, this is what it depicts. A lot of times, it's not always what it seems in the video. I have another version about how this happened. I have another version about why Mr. Gilchrist allegedly did what he did. And it's not just somebody walking somebody, cold cocking somebody, and just hitting somebody for no reason. Obviously, that's one side of the story. He has a side of the story that he will share. Time is right. Right now, Your Honor, this is a situation where we are at a bond hearing trying to determine whether he's a danger to the complaining witness, to society. I don't think he is. I think if the court wanted to put a tether on, if the court wanted to put house arrest, that would ensure that he stays in place. I know his parents would ensure that he stays in place and matriculate through the process so we can see all of the discovery, Judge.
1 second, Madam Prosecutor, are there any allegations of prior either contact or convictions of this nature?
There is not. That's what makes this so shocking.
Court haven't heard the arguments of counsel. Court finds that the $50,000 cash bond is an unaffordable bond. In order to have an unaffordable bond, there has to be a showing that the defendant poses a danger to the complaining witness, poses a danger to the community, and or is a flight risk. In this matter, there's nothing on the record that denotes anything dealing with flight. As to a danger to the complaining witness, as the prosecutor stated, the complaining witness is I believe, is a foreign citizen who must have been it's not a town guess, it's a foreign citizen, 81 years old, and the defendant and the alleged victim they don't know each other. So I'm not as concerned about a danger to the complaining witness. Now, whether Mr. Gilchrist is a danger to the community, that's definitely on the table based on the allegation that this is almost a random act of violence. I understand it's going to be a question of fact whether there were some aggravating circumstances that provoked or self-defense or misunderstanding. That will come at a later time for a trier of fact. Court finds the $50,000 cash bond is unaffordable. Court finds that there is another way based on the defendant not having a record to ensure the safety of the community. Cash bond is warranted in this matter. Cash bond will be $50,000, 10% with the GPS tether, and there will be a house arrest to the tether. The defendant will be able to leave the house for medical appointments and court appearances only, and no contact again with the complaining witness. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Madam Clerk.
Yeah, that's fine as far as MDOC.
Okay. Madam Clerk.
Yes.
I'm sorry.
Calling case number 24058320001, people of the state of Michigan versus Jamil Morgan. Defendant is being charged with count 1, weapons, firearms, possession by a prohibited person. Count 2, weapons carrying and concealed. Count 3, assault with a dangerous weapon, felonious assault. Count 4, 5, weapons, felony firearm, habitual offender, fourth offense notice. Today's the date and time for bond redetermination. Appearances, please.
Good morning, Lisa Coyle appearing on behalf of the people.
Jessica Scheib on behalf of Mr. Morgan. Mr. Morgan, please state your full name for the record.
Jamil Kadar Morgan.
Argument.
Your Honor, this incident allegedly is from May, entered in July. I don't believe he has any pending cases. He is employed with the city of Detroit. He was working full-time. However, he has been in custody since May, Your Honor. I'm respectfully asking the court to consider a personal bond, any bond.
What is his current bond? I'm sorry.
I see it at $25,000, 10%.
Okay.
And so, Your Honor, that is unaffordable to him. He does have his GED. He's a lifelong resident. I'm not aware of KP's history. Now, I do know that he has a criminal history. However, I do see it's from 2005. And then on 2017, that was non-assaultive. I believe it's a cell phone in prison. So it's non-assaultive. Respectfully asking the court to consider a high personal bond. And Your Honor, he's again been in since May. He will make it to his court dates.
Madam Prosecutor.
Your Honor, he does have an assaultive background from 2003. He had a great bodily harm as a juvenile. 2005, armed robbery, great bodily harm, felony firearm. And in 2017, a prisoner possessing a cell phone. The complaint in this matter, this is basically a road rage case in which the complainant was driving on I can't remember, I want to say I-75 with her 2 children in the vehicle. He allegedly took a weapon, pointed that out the window at her and her kids when he was driving next to her car. She gave the police a description of the vehicle as well as the plate number, and she gave a physical description of the suspect. That lien check of the plate comes back to an address that the defendant lives at. The lien check of the gun that was found at that address, the girlfriend has a CPL, and that gun is registered to her. It's a 9mm Taurus. The defendant's girlfriend had made a statement to the troopers that he had told her that a lady almost had run him off the road on I-75. He just got off the parole. They did a lien check on his home on May 23rd, which is right after this incident, 13 days, and the gun was found under the mattress. So it is a circumstantial case, Your Honor, but a highly assaultive and dangerous case, and people believe at $25,000, 10% bond is appropriate in this matter.
Court, having heard the arguments, counsel, court finds that the $25,000, 10% bond is an unaffordable bond. Court finds that the allegations in this matter of a random road rage case where a person on parole is pointing a weapon allegedly out of a window at a woman and their child is definitely a danger to the community. This is a random act. And court finds that the $25,000, 10% bond may be unaffordable, but based on the nature of this, as well as the defendant's past, it is an appropriate bond. Bond will continue.
Thank you.